What's up, grandkids? What's up? What's up? What's up? This will get started here shortly. So we have the lawyer argument this morning for this trial. Tomorrow morning they will be live again with the jury. So that'll be day 2 for Zachariah Anderson. Make sure you guys share this out. Let's get this out everywhere. See if we can get see if we can get a bunch of people in here. Brand new trial. We did day 1 last night. Opening statements yesterday. Today is a lawyer argument. And then tomorrow we'll be back officially to day 2. But this should be a good one, guys. This trial, the first time it went to trial, it ended up in a mistrial because of a witness statement. They're arguing more mistrial stuff right now. The victim, they have never found his body. So this is scheduled to start here in just a few minutes. Make sure you guys like the stream, hit that thumbs up, share this out, please, everywhere. Help us bring some people over. Make sure you guys, let me know where you guys are tuning in from. How you guys doing today? All right, so little background on what happened yesterday. So yesterday was opening statements. Now, this went to trial a first time, and because of a statement, it resulted in a mistrial. Now we're coming back. There's going to be a lawyer argument. Judge Schrader kicked the jury out yesterday. The lawyers argued for quite some time, and they're coming back to argue again today, and over a second possible mistrial. So Anderson is charged with killing Rosalio Gutierrez and hiding his corpse. He also has 2 charges of stalking for the disappearance of Gutierrez back in May of 2020. So this is a very high-profile case for us here in Kenosha. Another high-profile case. They have never found Gutierrez's body. Like I said, the first trial resulted in a mistrial. During the defense's opening statement, so she says, we have no explanation of what happened to him. We have no explanation of what Mr. Anderson, where Mr. Anderson would have put a body. We're going to run with him. The defense's theory is that the police investigation was shoddy, which we've seen in Kenosha many times. So she says, what did they ignore? They ignored Miss Beecham. Beecham is Anderson's ex and the new love interest of Gutierrez. Beecham is the one who found the bloody apartment. Again, no body. They've never found this man's body. So the defense attorney pointed to a text sent to the ex from her friend days before Gutierrez disappeared. She says, phone call has been placed. All I was told is it will begin, and you will not know when, where, or how. Call him in 1 week. What's 1 week later? When she's at Mr. Gutierrez's apartment. The prosecution objected to this, and the judge ordered the jury out of the courtroom for what he thought would be a few moments. This obviously took the entire rest of the day. So, Gravely, the Kenosha County District Attorney, he's the head district attorney out there. He says there's a whole body of case law that doesn't allow a private citizen to be accused. So at issue is this Denny rule. So this is from a previous case law. So he basically argues that if the defense wants to blame a third party for a crime, that requires pretrial hearings to show motive, opportunity, and direct connection. So the prosecution said the defense's statement is in direct conflict with the Denny rule. The jury heard what was said, and it cannot be undone. So Gravely argued this is a mistrial. You can't take away a suspect from a jury. The defense attorney says, I have not accused anyone of anything. Law enforcement honed in on my client and didn't investigate anything else. So the trial was stopped yesterday while they argued. Judge Schrader gave them until last night to hand in their briefs, and they are going to be arguing this today. So we're going to see what Schrader rules. Gravely, so it's a district attorney who's now asking for a mistrial over the statement. So this will be interesting if this goes to a second mistrial. Here we go. If you guys like the stream, share this out, please. Get this out everywhere. All right, let's listen in. This is going to be a spicy argument, guys. It's going to be spicy. Share this stream out. Hit that thumbs up.
Well, actually, I need it now. We're back, and the appearances are as before. The lawyers were kind enough to take the time to sit down and confer with one another. And there was also a submission by the defense, which I did review. Why don't you take it from there, Mr. Gravely?
So counsel will correct me if I make any representations she did not feel are completely accurate, but I believe that, apologize. I believe that based on the filing submitted by the defense, that the state and the defense have an understanding that the defense will not make any arguments that rise to the level of a Denny argument and not present any evidence that will rise to the level of a Denny argument. And they recognize that the argument that the state believed was a Denny argument was a sort of a connect the dots argument of some individual pieces of evidence, and they've indicated they will not make that sort of connect the dot argument that would rise to the level of Denny, and their submission reflects that. They have indicated to the court they have no additional Denny hearings that they are seeking from the court, even though the court gave them guidance if there was Denny-like evidence that they should put it in their submission. In light of that and understanding that I believe that to be an accurate interpretation of what they wish their filing to represent to the court, the parties were able to come up with a joint proposed cautionary instruction so that we did not have to have a mistrial in light of that pleading. That joint proposed cautionary instruction has been submitted to the court. All parties have copies. Does the court need me to read it, or does it stand in this record because it is a filed document?
I'll leave it to your choice or that of the other party. It doesn't need to be, but you're welcome to do so.
Well, I have no reason to. Do you, counsel? Okay, so we've come up with a joint proposed cautionary instruction. We're asking the court that be read at the conclusion of the defense's opening statement. That was the express preference by the defense counsel, which the state is fine with, so that it is in close proximity to the end of the defense opening statement. The court certainly will use its own discretion about whether it should be read at any other time, but that is the time that we are asking the court specifically to read it. The state is also requesting to the court that in light of the sort of connect the dots argument made by the defense, that the state be able to add to its witness list and to call in its case in chief a witness named Rebecca Jekyll. That's Jaeckel. We intend to present some evidence to refute the implications that were raised in the defense opening argument. And I don't believe the defense has any issue with that. I believe that's the entirety of our discussions. Is that, counsel, does that? Yeah. So I believe that is the entirety of our joint discussions.
All right. Is that a fair statement?
Yes, hold on one second.
Yeah. All right, so is that a fair statement of the situation?
Yes, with some caveat, but it is a fair statement. The caveat is that my conversations with the district attorney, as it relates to how I could perceive how he interpreted the statements made in my opening statement. I had told him that I could see how he would interpret it that way and how someone could interpret it that way, but that I'd hope he could see that we could also interpret it, the defense could interpret it in the way that we so proposed on Tuesday and also in our pleading to the court. And so there was kind of that mutual understanding that it could be seen both ways is kind of my my understanding of that conversation. And so that was why we found it amenable to prepare this proposed cautionary instruction, and that would really cure any concerns that the state would have as it related to the statements that were made during the opening. As far as when we are requesting it to be read, the state's assertion was correct that we're asking that it be read at the conclusion of the defense's opening statement. And then with Miss Rebecca Jekyll being added to the state's witness list, naturally no objection. She was on ours. I did confirm with the state that they will write up a summary of what was discussed with her about this text message that will be prepared and provided to the defense prior to her testifying. So we will have that information and can act accordingly when we receive it. So that's the only supplement that I have, Judge, but I think that what the state and myself have come to an agreement on is appropriate, and that the court should accept it and should allow this trial to continue.
So there's withdrawal of the motion of the state for mistrial?
Frankly, what we've tried to figure out is a way to move on at this point. So yeah, I'm withdrawing the motion for mistrial in light of the stipulations and the filing so that we can keep going.
What did I do in my life to merit such congenial attorneys? No, this is, well, I'll leave it at that. Now, this is not something which would reach an element of the offense. Well, that's the wrong reach. This doesn't actually constitute an element of the offense charged. So I don't think we need to obtain the consent of the defendant, but I assume he's familiar with the agreement and what it means. And if you want to discuss it a little bit more with your attorneys, you're welcome to do so.
If we could just have a brief moment. Naturally, I was not able to confer with my client. Should we go in the back?
Yep.
Thank you.
All right. So let's, while they're in the back talking, so the Denny argument, so I'll read you the short thing. So State versus Denny mandates that the defense in any trial cannot suggest other suspects for the crime the defendant is accused of without being able to support that accusation with a possible motive from the new suspect, a proven opportunity for the suspect to commit that crime, and the ability to place them within proximity to the crime scene. So it says if Zellner wants to introduce, so this is all part of a case, right? So if Zellner wants to introduce a new suspect and can find someone with a motive, but not opportunity, then they do not meet the Denny standard. The same goes for a suspect with opportunity, but no motive or proximity to the crime scene. According to Rolling Stone, Zellner filed a motion in July suggesting Bobby Dassey, Avery's nephew, as a suspect. It's important to note, however, Bobby was never suspected by law enforcement in Halbeck's murder. And Bustle's request for comment from Bobby's mother, Barb Taddick, about the ongoing case and his inclusion in the Netflix documentary was not immediately returned. Per Rolling Stone's report, Zellner claimed in the motion that new CD evidence, which was not shown to Avery's defense team in his 2007 trial. So this is another big the Avery case is another big ass trial that happened here in Wisconsin. You guys remember that? And they're talking about the documentary that happened. That's another one, dude. That's a whole situation of a trial. So Zellner claimed in the motion that the new CD evidence, which was not shown to Avery's defense team in his 2007 trial, allegedly includes images depicting sexual violence found on Brendan Dassey's computer. Brendan, Bobby's brother, was convicted in connection to Halbeck's murder and sentenced to life in prison, but has long maintained his innocence. Also, according to Rolling Stone, a computer forensics expert reportedly signed an affidavit claiming that most of these alleged images were accessed at a time where only Bobby would have been able to access Brendan's computer. Rolling Stone reported in the same piece that Zellner planned to use the CD evidence to argue that Bobby has an interest in sexual violence and that this alleged pre-existing interest could serve as a motive for killing Halbeck. So that's so this whole Denny thing has been used in tons of different trials. So this happened in 1984 is the Denny thing. So Kent A. Denny was convicted of first-degree murder following a jury trial in which his brother was a co-defendant. Denny raises 3 issues on appeal. First, he argues that he and his brother should have been tried separately. Second, Denny complains he was denied his constitutional right to present a defense when the trial court refused to allow evidence suggesting that any one of a number of third parties had motive and opportunity to murder Christopher Moore, and that he was also denied the opportunity to produce evidence showing that he has a tendency to fabricate stories. Third, Denny asserts that the trial court erred in refusing to allow defense counsel to review police investigation reports he claims would have supported his theory that others could have killed the victim. We are unpersuaded by any of Denny's arguments and affirm. Christopher Moore was found dead on January 26, 1982. An autopsy revealed that Moore had been stabbed 57 times and had bruises on his head. Police investigation ultimately centered on Kent and Jeff Denny. Both of them had made various inculpatory remarks concerning the murder to a third brother, as well as to friends and acquaintances. After a jury trial, Kent and Jeff Denny were convicted of first-degree murder. Further facts will be presented as necessary. So this is kind of a long thing. We'll kind of read until. So there's severance arguments. So Kent Denny claims that the trial court erred when it refused to. Here we go.
You know, I didn't tell the jury yesterday. I usually do.
Hang on,
but I
peoples.
don't let the lawyers participate.
Mr. Krizarek is not aware of that, evidently.
I usually try to shut them down, you know, but, and I will tell you that a former member of your office, before the time that you were the High Muckety Muck,
Ancient
actually ended it, what's that?
Ancient times.
Ancient times.
Yeah.
Actually walked out of here with a negative score for the year. He's a very bright individual.
It doesn't sound like it.
Well read, but he's impulsive and he guesses too quickly.
Yeah.
All right, I guess we got to go to work.
I have a couple of theories, but.
So you've had a chance to talk with your client?
Thank you. Yes, Judge.
Okay.
Okay.
Do you have any questions about this at all, Mr. Anderson?
No, I'm good, Judge.
Okay, any problems? Okay. All right.
Back at 9?
I will accept and approve the stipulation, and it will be given as you request. if I remember to do it at the close of your remarks, and if I do forget,
I will remind
remind
you.
me. And other than that, I think back at 9 o'clock. And anything else?
No,
Nothing.
All right.
thank you.
Enjoy this magnificent day. First day of meteorological spring.
Oh, Judge Schrader. He's so knowledgeable. All right, so 9 a.m. we will be live with this trial for day 2. But let me get back to this so you guys have a full history. You have a background. And then we'll end this stream and we'll go back to the Murdaugh trial on the other stream we have set up. Okay, so this is the severance. So Kent Denny claims that the trial court erred when it refused to sever his trial from that of his co-defendant. He maintains that severance was mandated because the state intended to introduce testimony of inculpatory statements by his co-defendant. When reviewing a denial of a motion for severance, our standard of review is whether the trial court abused its discretion. And that comes from Cranmore v. State, 85 Wisconsin 2nd, 722-755, blah, 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 all these other numbers. Then he bases his argument for severance on the ruling of the United States Supreme Court in Bruton v. United States. The court in Bruton held that severance is warranted where a co-defendant's statement will necessarily implicate another co-defendant. In a subsequent United States Supreme Court case, Parker v. Randolph, the Bruton rule was modified. A plurality in Parker held that the admission of interlocking confessions with proper limiting jury instructions did not violate the defendant's right of confrontation guaranteed by the 6th and 14th Amendments. Interlocking inculpatory statements are those statements that clearly demonstrate the involvement of each defendant as to crucial facts such as time, place, and activity, and an awareness of an overall plan or scheme. Here, the trial court decided that the rule in Parker controlled this situation because the prosecution intended to present testimony of interlocking inculpatory statements by both co-defendants. The defendant, Kent Denny, objects to the court's ruling for 3 reasons. First, Denny claims that his statements and his brother's do not actually interlock because Jeff's statements are more comprehensive and detailed than Kent's statements, and because Jeff's statements constitute a line of evidence that is relevant only to Jeff's culpability. We review the inculpatory statements de novo to determine whether they were subsequently similar. On critical points, State versus Smith, upon review, we conclude that even if Jeff's statements were more detailed and comprehensive than Kent's, that does not prevent them from being interlocking. There are no apparent inconsistencies in the inculpatory statements, and the statements are substantially similar in terms of the crucial facts and an awareness of an overall plan. Although the statements are not identical, there is little doubt that the statements of the 2 brothers describe the same crime. See United States v. Fleming. In response to the line of evidence objection, we are convinced that Jeff's statements about the disposal of the murder shoes coincides with Kent's admission about the disposal of the murder shirt and corroborates their reliability. The statement suggests mutual activity to further the overall scheme of the crime and its concealment. Second, Denny asserts that the trial court's reliance on the Parker ruling is misplaced because a plurality decision cannot be given precedential authority when a narrower concurring opinion has been filed. We need not decide that point because of the rule of the Parker plurality has been adopted by this court in State v. Smith. The court in Smith held that interlocking co-defendant statements are per se admissible. Therefore, the Parker rule is now the rule in this state, and we are bound to follow it. Third, Nans, what's up, Nans? Denny is a high standard to prove, as all aspects have to be proven as possibilities. You are charged with murder. The prosecution is not required to prove motive, but Denny requires motive. Interesting. Then he challenges the denial of severance for one additional reason. He claims that severance was required because of the antagonistic defenses asserted by the co-defendants and cites Jung v. State in support of that proposition. Jung does not apply here. However, because it was not the defense that were antagonistic, but rather the tactics of respective counsel. Counsel differed several times on the degree of emphasis and on the lines of questioning. Although these differences represent different defense tactics, they do not constitute antagonistic defense theories. In fact, the same defense theory was pursued by both of the Denny brothers. The theory was that neither Kent Denny nor his brother Jeff perpetrated the murder, and all of the state's witnesses who gave testimony about the defendant's inculpatory statements were liars or could not otherwise be considered credible witnesses. We conclude that defense counsel did not present antagonistic defenses, but rather employed different tactics. We further point out that Wisconsin courts have been reluctant to find that assertion of antagonistic defenses justify severance. See Haldane versus State. We hold that the trial court's denial of severance was not an abuse of discretion. Pondering who I can't stand more, Jamboy or Binger. It's a tough one. Well, what about Gravely? Gravely's the one that's doing the trial now. Gravely is another one. Part of Kent Denny's theory of the case was that he was not the perpetrator of the crime, and his inculpatory statements were due to his proclivity for storytelling. He claims he had no motive to murder Moore, but others did. Denny attempted to present evidence by means of an offer of proof to support his theory that others had the motive to kill Moore. At the same time, Denny sought to prove that he had a reputation as a liar, which would explain his inculpatory statements. The trial court refused to allow Denny to present evidence suggesting that others might have had a motive, ruling it irrelevant. Denny correctly notes that even though the right to present witnesses in his own defense is a fundamental constitutional right, that evidence must be relevant to the issues being tried. And that's from Milenkovic versus State. He asserts, however, that if he can show how other people had a motive to murder Moore, he can establish the hypothesis of innocence. See State versus Wedgeworth. Hence, the evidence is claimed to be relevant. The general rule is that evidence of motive of one other than the defendant to commit the crime can be excluded when there is no other proof directly connecting that person with the offense charge, as stated in People versus Green. It is settled, however, that evidence that a third person had a motive to commit the crime with which the defendant is charged is inadmissible if it simply affords a possible ground of suspicion against such person. Rather, it must be coupled with substantial evidence tending to directly connect that person with the actual commission of the offense. The rule is designed to place reasonable limits on the trial of collateral issues and to avoid undue prejudice to the people from unsupported jury speculation as to the guilt of other suspects. The Green Court reasoned that general proof of opportunity and criminal disposition raises at most a bare possibility that a third party might be the culprit. We agree with the Green Court's rationale explaining why there must be more than general proof of opportunity and criminal disposition. The Green Court stated that there must be, in addition, evidence directly connecting a third person with the offense charged. We accept that statement. We disagree only with the Green Court's conclusion that such evidence must be substantial. We perceive this to be too strict a standard for the admissibility of such evidence and conflicts with our Supreme Court's pronouncements on the fundamental standards of relevancy. In our state, admission of testimony is allowed if the testimony tends to prove a material fact. See also State versus Farr. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. The rule does not say that the evidence must tend to prove a fact in a substantial way. We are convinced that Section 90401 commands us to adopt a standard less severe than the California court. A better standard was developed in the early case of Alexander v. United States. In that case, the United States Supreme Court fashioned the legitimate tendency test. In other words, there must be a legitimate tendency that the third person could have committed the crime. We believe that to show legitimate tendency, a defendant should not be required to establish the guilt of third persons with that degree of certainty requisite to sustain a conviction in order for this type of evidence to be admitted. On the other hand, evidence that simply affords a possible ground of suspicion against another person should not be admissible. Otherwise, a defendant could conceivably produce evidence tending to show that hundreds of other persons had some motive or animus against the deceased, degenerating the proceedings into a trial of collateral issues. The legitimacy tendency test asks whether the proffered, I don't know how to say this word, Proffered, proffered, am I saying that right? That's a weird word. Evidence is so remote in time, place, or circumstances that a direct connection cannot be made between the third person and the crime. Thus, as long as motive and opportunity have been shown, and as long as there is also some evidence to directly connect a third person to the crime charge, which is not remote in time, place, or circumstances, the evidence should be admissible. By illustration, where it is shown that a third person not only had the motive and opportunity to commit the crime, but also was placed in such proximity to the crime as to show he may have been the guilty party, the evidence would be admissible. See Perry v. Watts. And then there's a Perry v. Russian. Or where a third person has committed or actively seeks to commit violent acts against the victim or has threatened the victim in a manner not remote in time, place, or circumstances. The evidence might likewise be admissible. See Alexander. See also Harrison v. State. Our decision to adopt the legitimacy tendency test is supported by an old Wisconsin case, Lasecki v. State. In that case, the defendant claimed he was wrongly prevented from introducing evidence that a third party might have committed the murder for which he was charged. The defendant wanted to show that the victim conducted an illegal liquor business and made enemies. The court wrote, this proof was offered for the purpose of raising a question in the minds of the jury as to whether some such enemy might not have been responsible for the death of Armstrong. The fact that someone else may have a motive to commit a crime does not make such proof admissible, unless accompanied by proof tending to connect the person having such motive with the commission of the offense, or at least tending to show that such person was in the vicinity at the time that the crime was committed. Hang on, how are we doing on the other? Trial. I had to take this out of my head. So I missed part of that statement. That's all right. All right. Thus, while the Lasecki court vacillated between creating a standard requiring only motive and opportunity and a standard requiring motive, opportunity, and a direct connection to the crime, such that no clear standard was established. The fact is that Lasecki did use the term tendency. While our decision establishes a bright line standard requiring that three factors be present, i.e., motive, opportunity, and direct connection, our holding is consistent with the Lasecki language regarding the term tendency. Using the legitimate tendency test, Denny's offer of proof was deficient. One proposed witness would have testified that Moore may have gotten into trouble with a big drug dealer. There is neither motive nor opportunity shown here, much less a direct connection between the drug dealer and the crime. The same proposed witness would also have testified that Moore owed one Gary Peterson the sum of $130. Even assuming motive has been established, neither opportunity nor a direct connection to the crime was established. A second proposed witness would have testified that Moore may have had an enemy in Bill Cudahy because Cudahy gave Moore a shotgun in exchange for a controlled substance. Moore sold the shotgun, allegedly making Cudahy angry. While motive has been established, no evidence of either opportunity or direct connection to the crime was preferred. We conclude that the trial court did not abuse its discretion in refusing to admit this testimony. In the course of investigating the murder of Moore, the police followed many different leads in an effort to identify suspects. Defense counsel requested copies of all written investigative reports to determine, in part, if the contents might support Kent Denny's theory that others had a motive to kill Moore. In response, the district attorney turned over some of the reports but submitted others to the court for inspection. After the court reviewed the balance of the reports in camera, the court declared the contents irrelevant and refused to disclose them to defense counsel. On appeal, this court authorized defense counsel and the attorney general to read the investigative reports and to argue whether the trial court erred in its decision. Having read the reports, Denny claims that failure to allow his counsel to read the reports prior to trial prejudiced his case. Questions concerning the relevance of particular evidence are to be determined by the trial court's exercise of discretion. This court will not find an abuse of discretion if there is a reasonable basis for the trial court's determination. Before reaching that question, however, we note that the defendant frames this issue in terms of the state failing to disclose exculpatory evidence. We disagree with the defendant's characterization. In fact, the state relinquished sole possession of the evidence when it submitted the materials to the court. The state alleged that this evidence was not exculpatory and that its production at trial would merely create peripheral issues which would unduly distract the jury from the main issues. We are persuaded that the state's willing production of the reports to the trial court distinguishes this situation from the kind of problem faced in Roll versus State, where exculpatory evidence was allegedly withheld. In that case, the state arguably kept information from the defendant and the court. The issue here is whether the trial court abused its discretion in finding that the contents of the police reports were not exculpatory, not whether the state failed in its duty to turn over exculpatory evidence. Having determined the correct posture of this issue, we now reach its merits. The trial court stated during the hearing on pretrial motions that its review of the sealed investigative reports in question did not disclose anything of importance to the trial. The trial court acknowledged that some of the persons identified in the reports were the same as those mentioned in the Denny proceedings, but nonetheless found the information irrelevant even as to the credibility of witnesses. The trial court understood that defense counsel had been given copies of all of those investigative reports that did supply relevant and possibly exculpatory information. We have thoroughly reviewed the contents of the sealed investigative reports. We conclude that no exculpatory information existed, which would have helped Denny in his pursuit of admissible evidence relating to third-party culpability. Most of the 236 pages show nothing more than an ongoing investigation of the crime. None of that information would have been helpful either in the preparation or submission of admissible evidence in Denny's defense. Denny's argument that there are numerous references to persons having information about the murder is of no import. There is no importance. There is nothing exculpatory in any of that information. His claim that one person gave detailed descriptions of the wounds on the body is also of no moment because there is no hint of motive or opportunity which could be used by Denny in attempting to get this particular evidence before the jury. Finally, Denny argues that the reports show names of those believed by others to be involved. In the majority of these instances, this information can be classified as nothing more than finger-pointing gossip. In only 3 instances can a motive to hurt Moore be conceived. In the first, Gary Peterson threatened Moore with harm for not repaying a loan. The problem is that Peterson was incarcerated at the time of the murder. He had no opportunity to commit the crime. In the second, Bill Cudahy is listed as having been angry with Moore, but the report provides Denny with no more information than he had available in his offer of proof. Third, it was reported that someone thought one Randy Peterson might possibly be angry with Moore because of Moore's encroachment upon Randy's drug territory. There's nothing in the report, however, that would help Denny show a direct connection to the crime. In sum, none of the material would enhance the admissibility of his preferred evidence or bring up additional evidence. The trial court properly refused to allow inspection of the documents by the defendant's counsel. Denny also claims that even if not exculpatory, the information would have been helpful to defense preparation and investigation. However, the state is under no constitutional obligation to provide the defense with discovery of helpful but non-exculpatory evidence. See Brighton versus State. A lot of these cases, it's just kind of crazy. And when you think about it, when you have like a defense that you have to put on, and the courts are not requiring this the state, but then the state's like, well, we don't even want to give it to the defense, and then they give it to the judge to review privately. That's called in-camera viewing, and then the judge can decide, and the defense still never sees it. That's just so crazy to me. That's how our court systems are. But I don't know. It's just crazy. Finally, the defendant claims that 2 pages of the investigative materials show that a key prosecution witness lied. We agree with the state that this characterization is incorrect and that this evidence has no impeachment value. Kent Denny argues that the statements of Jeff Denny were not admissible under the conspiracy exclusion from the hearsay rule contained in section 90801. You guys know that section, 90801. Because the trial court failed to make the necessary factual findings of the existence of conspiracy. Then he makes that argument in answer to the state's claim that the inculpatory statements were interlocking because they showed the involvement of each as to the crucial facts and an awareness of an overall plan or scheme. See Parker v. Randolph. Our reading of the transcript, however, shows that the trial court explicitly found a continuing conspiracy following Moore's death. In a response to a specific debate concerning this subject, where the defendant told the court that it had not made any findings that a conspiracy existed or continued to exist following the death of Moore, the court replied. The testimony of Trent Denny is that about 2 or 3 weeks after Jeff had talked to him, they talked with Lori about getting rid of the clothes, and both said they had to get rid of the clothes. I'm not holding that the conspiracy ended when Christopher's death was terminated. Certainly, then, the acts of the 2 defendants after they disclosed their participation to others in the family and others of their friends and then asked for help to get rid of the clothes. I think it's all part of that one thing, and I will deny the motion here. Although we do not need to resolve whether adoptive admissions are an exception to the severance statute, we note that some of Kent Denny's statements qualify as adoptive admissions because they were responses to Trent Denny's questions about co-defendant Jeff Denny's statements. So there you go, chat. That is the entire Denny case summed up for you. So we will be back tomorrow, 9 a.m. Central Standard Time for day 2 of Zachariah Anderson. Big Kenosha case for us out here. You know, we like to cover Wisconsin cases. So we will be back. Make sure you guys tune in. We're going to keep deep diving. We're going to keep looking at stuff during breaks. We're going to talk about this. We're going to talk about things that you guys have questions for. We're going to be looking stuff up during the trial. And remember, try to be here as much as possible because at the end of this trial, we are going to do another mock jury like we did for the Jensen trial. So I've already started putting posts out on our Facebook platform, NSM News Updates. We put the Jensen mock jury that we did, we put that up on the page. It's also on the YouTube channel. So you guys can see what it's all about and what we did, how we set it up, and you can hear all the viewers that are in our jury box debating the Mark Jensen, murder trial as if they were legitimate jurors. So we'd love to do that again. Let's try to get a bunch of people in here when we go live, share the streams out, but we'll go live a few minutes before 9. Make sure you guys are here tomorrow. We are live on another stream right now with the closing arguments for the Alex Murdaugh. So we're going to end this one if you guys want to jump over there and follow that. Otherwise, we will see you tomorrow morning.